I'd like to start off today by welcoming back the audience from part one to part two of the Court of Public Opinion radio show interview with none other than Super Attorney Oliver Max Gardner III. However, before I introduce today's guest, I would like to introduce to you my lovely co-host, Janet Reiner from MIRSnow.com. Hi, Janet.
Hey, John. Hi, guys. How's everyone doing?
Well, we're doing a heck of a lot better now that you're back, Janet. We certainly missed you during part one, which we explained to the audience that you were unable to be a part of due to the fact that the content was a little too emotional for you.
I think I would have been able to, but it would have been extremely difficult. I think being a mother of 4 children, as he was reliving that tragic night, it takes me back into my own personal fears of what may or could happen to any one of my children. And I think that was one of the concerns that I had, is that as I was listening to the interview, you sort of think and identify with the possibility that it could have been you or me.
Oh, I couldn't agree with you more, Janet. And I'm sure that anybody in the audience who listened to part one of the interview understands your reasons for not being able to be there. But nevertheless, you did get a chance to listen to it off the air, and I wanted to see what you thought of the interview.
It was such a powerful interview, and I have to admit I cried.
Oh, yeah, it was definitely a very, emotionally charged and very powerful interview, without a doubt. I think the two things that impacted me the most was, picturing Mr. Gardner sitting there, writing that 45-page letter to his son. I mean, it was just heart-wrenching. And I think that the audience and me, both connected with him at that point, and just saw a man that was so racked with grief that was so desperately seeking closure. But I think that the other thing that impacted me a lot was the ending, with how I asked Mr. Gardner to explain Oliver Max Gardner IV, his son, to the audience through his eyes. And I think that that's where we all started to have our eyes get a little watery, but I couldn't help but think of how I could only hope my father would explain me in the same way. And I was just so very proud of Mr. Gardner, and really just thought he was such a class act. And what a not just what a super attorney, what a super father. I mean, what impacted you the most, Janet?
The most impactful thing that I heard was the fact that no matter what pedigree he came from, no matter what accomplishments he had in his life, it's very true that no matter what we do in our own lives, the most important thing is family. And no matter how much money you have, no matter how much you accomplish, not having that family and recognizing all the tragedies that have occurred has such a tremendous impact. And not only that, but also the way he overcame it. I'll tell you something. The inner strength, the intelligence, the compassion, the fortitude to be able to work your way through such a tragedy is really very, very impactful. Not only for what he did, but also how it affected me and the way my dynamics and my relationships are.
Well, I really couldn't agree with you more, Janet Reiner, and I'm sure that you'll agree with me when I say that there was probably not a parent or a person who's raised a child who did not put themselves in that position that Mr. Gardner was in, which was to sit there and write a 45-page letter to basically say goodbye to your child. And, but I think it's important to say, for the record here, that Mr. Gardner told his personal story with hopes that the impact that it would have is to provoke positive change. And that positive change being to remind people not to drink and drive, and to maybe, make such a simple choice such as having a designated driver, because, basically such a simple choice of having a designated driver would have made a big difference in Mr. Gardner's life, and maybe his son would still be with us today. But Janet, we've talked about Oliver Max Gardner III as a super dad in part one, and today we're going to talk about Oliver Max Gardner III as a super attorney, because basically Mr. Gardner is one of the most well-known consumer bankruptcy attorneys in the entire United States. And he's been featured on such worthy news organizations such as ABC Nightline News and CNN and Businessweek and the New York Times and the Washington Post. But today, Janet Reiner, he's being featured on the Court of Public Opinion radio show. And therefore, ladies and gentlemen of the Court of Public Opinion, with no further delay, it gives my co-host Janet Reiner and I the distinct privilege to reintroduce to you Super Attorney Oliver Max Gardner III. My co-host and I, Janet Reiner, would like to take this opportunity again, Mr. Gardner, to thank you for answering our subpoena to appear again on the Court of Public Opinion radio show. However, with no further delay, it gives me great pleasure to introduce you to my lovely co-host, Janet Reiner from MIRSnow.com.
Mr. Gardner, are you there?
I'm here, Janet.
Okay, Mr. Gardner, I got to tell you, I am so nervous talking with you.
Just remember that I'm just a country lawyer from Western North Carolina, a big fan of Willie Nelson and Waylon Jennings, and so don't be nervous or anything like that talking to me.
Well, I am, and here's the reason why is because you are so instrumental in educating so many wonderful, phenomenal attorneys. And from what I understand, you have a book of attorneys that you have educated and trained regarding bankruptcy laws and bankruptcy cases. That your attorneys that you push out are phenomenal, and I have nothing but wonderful things to say about that. And so you are a premier attorney, so I am very nervous about talking with you.
Well, if it makes you feel any better, Janet, I've been nervous the entire time, and for good reason. This is a huge guest that we have on our show today, and there's only one person bigger than him, I think, in my mind, and that would be the President of the United States. But now that I think about it, I'm more nervous talking to Mr. Gardner than I am the President of the United States, because clearly Mr. Gardner's had more wins. Okay, I don't want anybody to go Dixie chicking me right now. I was just kidding. All right, it was just a joke. But anyways, what I was saying, Janet, was I've been pretty nervous too when I think about how Mr. Gardner's like E.F. Hutton. I mean, when he speaks, everybody listens, and all it would take is him saying something like, you and Janet Reiner are the dumbest people I ever met, and nobody would come anywhere near us, and we'd never have an interview with anybody ever again. But then again, we could get him back, Janet, and when we're featuring him in this interview, put the title street dweller under his name instead of super attorney.
Oh, my God.
I'm just kidding, Mr. Gardner. My co-host and I, Mr. Gardner, would like to talk to you a little bit about your Max Gardner Bankruptcy Boot Camp, which is one of the most prestigious and sought out for foreclosure defense boot camps out there. I think probably the best way to go about this, though, is to maybe cut away to a documentary here about the boot camp. And then when we get back, Mr. Gardner, me and my co-host are going to have some questions for you.
I wanted to talk to you briefly this afternoon about what I call the bankruptcy litigation model. My theory about how you represent consumers effectively in either Chapter 13 or Chapter 7 bankruptcy cases. I have said for years that if Congress changed the bankruptcy law to require me to take Chapter 13 cases for no fee up front, I would continue to do so because of the litigation opportunities that are involved in those cases.
The materials that are provided are extraordinary. The time that the materials alone have saved me in terms of preparing motions that I come across regularly in the course of my practice was worth the price.
Not only do I practice consumer bankruptcy law, but I consult with law firms on how to run their law practice more effectively. I saw a lot of value in being able to advise other attorneys on how to generate more revenue out of representing consumers.
Mr. Gardner, could you please tell us a little bit more about the Max Gardner Bankruptcy Boot Camp?
What we've tried to do in the last 11 years is to educate bankruptcy attorneys on all the consumer protection statutes that are out there, and to be able to identify those claims and then how to pursue those claims in a bankruptcy case. So we want them to be more than just bankruptcy attorneys, but really consumer advocates. And I guess we've had, 1,800 attorneys that have been through our seminars in the last 11 years. And we have a, confidential listserv where we communicate every day and have a document repository of probably 25,000 documents right now. So, it's been a great thing in the sense that we operate like a very large law firm every day, and you're just not out there by yourself. And if you've got a question, you need support or help, there's plenty of folks that'll answer questions or give you forms or cases or statutes or throw out legal theories and see what everybody thinks about them. And I think that's probably been one of the more important things that I did, was starting that listserv from the very beginning.
Well, maybe you can explain to us, Mr. Gardner, how you came up with the boot camp concept. Kind of give us the how, what, when, and where.
Well, it really wasn't my process that had anything to do with it. I was doing a lot of seminars for, like the National Association of Consumer Bankruptcy Attorneys, the National Association of Consumer Advocates, throughout the country in the late 90s and early part of this decade. And my wife said one day, or maybe over the course of several days, why don't you start doing something here at our farm in North Carolina, and then you won't have to travel so much. You can just, the people will come here. And, I thought about that for 5 or 6 months, and we discussed it, and we realized we had, enough room at the farm to get 12 or 13, 14 attorneys in at one time for a seminar. My wife and I had operated a bed and breakfast inn for 10 years, and we had a little experience with how to be a good host, and she's a fabulous chef. So that's how it all started.
So I guess what it is that you're saying is that the old saying's true, that behind every good man is a good woman. Is that what you're saying, Mr. Gardner?
Well, a good partner.
Isn't it amazing how sometimes the best ideas come from women?
Well, we've had some of our best graduates have been women attorneys, and we've had so many that a lot of them just have no fear, and that's really what you've got to have is no fear of doing something you've never done before. And I've been very proud of the work of all of our boot camp grads, not just a couple, but and I see an American Bankruptcy Institute seminar, and they've got 10 speakers, and 7 of them or attorneys who've graduated from our boot camp, that's the kind of thing that makes you feel like, well, maybe we're doing some good.
Absolutely. Absolutely. I had mentioned Ha Dow. She is one of the best attorneys in Washington State that I'm aware of. I'm sure there's plenty. But you do have a list on your website of the members who have gone through your boot camp, and that's a list of just about. I'm recommending everyone to go through and utilize those specific attorneys because they are very well educated, very well trained, and it is the premier. It's the premier attorneys that are being able to argue these cases to the proper end.
What my co-host Janet just said to you, Mr. Gardner, made me think of another question. There are plenty of attorneys out there who have attended your boot camp and already know how the whole thing goes. Nevertheless, I'm quite sure that there's quite a few attorneys out there that are thinking about going to your boot camp, or maybe you have already signed up and have never been there yet. This is ultimately the reason, Mr. Gardner, that my co-host and I and the Court of Public Opinion radio show sent a secret film crew out there to film what it's like when the students arrive and you and your wife are standing there to greet them. So we're going to cut away to that clip right now, and then we'll talk a little bit about it when I get back.
Smiles, everyone, smiles.
Okay, so it wasn't your ranch, Mr. Gardner, but, my point being that Janet and I both, picture it being something like Fantasy Island, where you and your wife are standing there greeting us. And Mr. Gardner, can you please tell us, what should a new student coming to your boot camp expect the minute they get to your property?
Well, we're in kind of a remote location. Our farm is in the South Mountains of western North Carolina, so there's nothing within 20 miles of our farm, but the farm animals we have are dogs and wild animals, so there's no distractions. So I think when people first get there, the thing that impresses them more than me out there saying welcome to the farm or the boot camp is just the geography and the scenery. It's just very beautiful out there. And just the remoteness of it, and that's been a big factor in the boot camps because there's no distractions. I mean, we usually have 12 hours of intensive training every day, the 4-day seminar with a half day first day, the 4.5 days, and we have all our meals together. So we're constantly talking. Legal talk, so to speak, 16, 17 hours a day. So it's hard to explain, what it's like. I tell people that, they need to be prepared for a physical and mental overload because that's really what it turns into is, you can't do everything at once. I mean, we cover so many different consumer protection statutes and legal theories, not just how to do a bankruptcy case right, but how to pursue every claim that may arise out of a bankruptcy case. But you can't do it all at one time and just don't get overwhelmed by it. And when you get through, start with the if you're doing bankruptcy, do it the right way and do it the way we're trying to instruct you and teach you to do it. And then start with the thing that is most comfortable for you to start doing that you hadn't been doing before, and then just proceed step by step after that. But it's a very scenic place. Everybody is there together, and it's an intensive 4.5 days. There's no doubt about that.
Well, I've seen pictures of the property, and it just looks like an absolutely beautiful place to be. I mean, it looks very, just very serene.
Yeah, it was. It was going to be some sort of religious retreat I actually bought the property about 11 years ago from the individual who was going to start it as such, and maybe some of that has rubbed off on the property and the boot camps. I don't know, but we've had some kind of divine intervention of some sort.
Well, when in these boot camps, when you talk about legal theory in some of this other education that you're doing, I'm sure a lot of these attorneys are coming from a wide array of arenas, not arenas, but different areas of law. But do you find that one area of law is better in preparation to do in bankruptcy or no?
Well, really, bankruptcy, to do it the right way, combines so many different areas of the practice of law. I mean, from contract law to the Uniform Commercial Code to the Fair Debt Collection Practices Act to the Fair Credit Reporting Act to your state unfair and deceptive active practice statutes to truth in lending. Just everything, real estate, title work, understanding securitization and how it affects every consumer receivable. It's the only area I think that brings in so many different areas of law all into one place, and that's really what our objective is at the boot camp, is to let the attorneys appreciate that this is not just a bankruptcy case that they're filing, that this is a case that any claims that consumer has that are not directly bankruptcy related, you're going to be able to identify and pursue properly, and any claims that arise during the bankruptcy case, you're going to be able to identify those claims and know what to do about them. And then after the bankruptcy is over and the debtor has gotten a discharge, then what kind of claims should you be looking for at that point?
Well, Mr. Gardner, I have to ask you a question, and I promise to keep the answer between just you and me, because I'm sure it's a secret. Mr. Gardner, you have tried 102 cases to verdict, and been successful in every single one of them except for two, in which one of them that you lost, you retried and actually won. Therefore, my question is this: what is your secret?
There's no secret to anything in this business. It's preparation, and hard work, organization. From day one, I always try to reverse engineer every case that I have in terms I'm thinking, if a case goes to a final decision by a judge or a jury, what am I going to have? What are the factors? What level of proof do I need to establish, that case at that point? What are my damages? How am I going to prove those damages? I just work my way backwards from that point. So I'm trying to I always say I never file a case to settle a case. I file a case to try a case, and that's always been my philosophy. Is I don't file them to settle them. I file them to try them out. And obviously the vast majority of cases are settled, but you can't get in there and say that this case is going to settle. You have to approach every case, I think.
Mr. Gardner, let's talk a little bit about some of these cases that you seen to final verdict. I mean, I'm sure the audience is very excited to see what it was that you basically did, or, what arguments you made, or what it was that the banks did that you were able to be successful in going to court with. I mean, we're talking something like 102 you took to final verdict, in which two you lost, and in one of the ones you lost, you retried and won. It's quite an impressive track record. So I think that the best way to describe what you do is to cut away to a news clip of you on Nightline. And when we come back, my co-host Janet Reiner has sent me an email here expressing that she has a question for you. So we're going to cut away to that clip right now. When we come back, we're going to have a few questions for you.
find themselves in the same situation with their servicers. Some of them file for Chapter 13 bankruptcy.
They claimed they had an agreement.
And these attorneys say bankruptcy courts have become an unlikely ally in exposing loan service abuse.
There's just no accountability in this system from the ground up.
Here in the gentle hills of western North Carolina, Max Gardner is holding a 4-day bankruptcy boot camp. He's trying to mass an army onto the complex battlefield of credit servicing.
There's no way, that I can train 10,000 lawyers, but maybe 200 can train 2,000, and they can train 2,000 more and 4,000 more and keep going. You have to assume everything that they give you is not accurate. And you really have to ask for, verification beyond verification.
Lawyers from around the country come to Gardner's rural retreat to learn how to dissect their clients' records, rooting out the hidden fees mortgage servicers charge. Those fees can add up to tens of thousands of dollars.
Are the fees actually illegal, or are you saying they're just improper? They're just too much?
I'm saying they're both. I'm saying the fees are unreasonable fees, they're unnecessary fees, they're improper fees. These guys are smart, they're playing the odds, and the odds are that 95% will just go ahead and pay it.
Kentucky attorney Carol Friend presented a case she recently won, a couple who discovered a huge discrepancy between what they thought they owed and the amount the bank wanted.
The payoff when they started on their mortgage loan was $43,361.27. When everything was said and done in this case, the total payoff on their mortgage loan was $76,644.20. There were $33,000 charged against this mortgage loan.
Gardner says fees seem so innocuous that often he has to bring in a forensic accountant to uncover what's legitimate and what's not.
How much is he finding fees that shouldn't be charged?
I don't know of a case he's ever looked at that he didn't find fees that shouldn't have been charged.
In fact, Professor Catherine Porter of the University of Iowa studied 1,700 cases of bankruptcy, often finding no documentation that would explain questionable mortgage servicing fees.
The problem is, without that documentation, it's very, very hard for the homeowner or his bankruptcy attorney or the bankruptcy court to make sure that the debtor is being charged the correct amount.
Porter says it's because servicing companies aren't really in the business of pleasing customers.
No matter who you take your loan out from, you have no control as a homeowner over who's going to be servicing your loan. And the mortgage servicers know that. One of the most frightening things that I found in my study was the problems with mortgage servicing. They're not a one bad apple story. The problems are very, very systematic. Nearly every single servicer employs the same bad or incomplete or inaccurate processes.
The wall of shame,
Bankruptcy judges have responded. Gardner's wall is covered with copies of checks from judgments he's won against a variety of mortgage servicing companies.
We display these checks on the wall to sort of give my boot campers some encouragement.
I can't believe the amounts of the checks, though. I thought we'd be talking about small amounts, like they overcharged you $150, $300, something like that.
You have a lot of time, a lot of opportunity to put a $150 fee here, a $350 fee here, a $20 fee here, and it adds up.
Adds up to $25,000, $55,000.
Right. It can add up to some very serious money.
How widespread is this practice?
Every case, every loan I've seen. Every bankruptcy case I've seen, there's some kind, even if it's $85 BPO that shouldn't be charged, something like that, every case.
Gardner wants Congress to pass a federal mortgage servicing act requiring full disclosure of all fees.
We just want complete transparency. We want to know exactly what's going on. It's my money, my mortgage, my loan. If you want to charge something to it, I have the right to know, and I might agree with it, I might not.
And he says it's not just financially distressed homeowners who find themselves the victims of mortgage servicing fraud.
Whether you're AAA credit or single D credit, you need to write your servicer at least once every 6 months and ask them for a payment transaction history.
Because, critics warn, with less business coming in from new loans, mortgage servicers will be even hungrier for other ways to make money. This is Vicki Mabry for Nightline in Shelby, North Carolina.
Janet, why don't you go ahead and ask Mr. Gardner the question that you have?
I was anxious to ask you a question. Now, I was looking through a lot of the cases that has been listed on your website, and I noticed that you have a lot of cases that were against Associates Financial Services for alleged willful violation of the automatic stay. Do you find that a lot of companies do that? They violate the automatic stay?
The associates, I always said the associates was the mafia of consumer lenders. It really started out as Ford Consumer Finance. It was a division of Ford Motor Credit Company, their subprime division. And then they spun it off into the associates. And, the associates then bought AFCO. I don't know if you remember AFCO Financial, but AFCO was probably, the second worst other than the associates. And then I think around 2001, Citibank acquired the associates. So that was marriage made in hell, for sure. But yeah, the associates just, you've got to understand how creditors look at consumer protection statutes or the bankruptcy code is they know what they're doing violates the law. Well, there's no doubt about that in my mind. But they're looking at it in terms of how much is it costing us to violate the law versus how much are we making by violating the law. It's a cost-benefit analysis, like the Ford Pinto and the gas tank, or GM and the ignition switch. The gas tank would have been $8 or so to fix. The switch would have been $2 or $3, but they multiplied that times the number of fixes it have to make, and decided, well, that's going to be too expensive. And I think, over the years, that's been my experience in dealing with creditors, is that they always do that cost-benefit analysis. I had a story about the associates. I had, back in the 90s, I had so many automatic stay violations with the associates that it would be like every day we'd have 3 or 4 more violations. And I finally filed this massive discovery request, and the associates filed a motion for protective order saying it was, too burdensome on them to do it. They just couldn't produce all these records and documents, and too expensive. And the bankruptcy judge, Judge Marvin Wooten, who was a great bankruptcy judge, he's deceased now, but Judge Wooten said, Mr. Gardner, do you want to go to Texas? Because their main office was in Arlington, Texas. And I said, well, not especially, but if the documents are there, I'll go. And so we went down there, and I spent 2 days in a warehouse that was not air-conditioned, like 3 football fields big, at a camp. And we looked through documents and actually found a memo about me from the senior vice president of the general counsel's office to the general counsel, and it was evaluating what their problem was and why I was filing so many automatic stay violations. And what it was is they had a software problem when they acquired AFCO, and they imported all the data into their system of record. There had been a logarithm problem in the software that when associates got notice of a bankruptcy, it would disable all normal collection activity in that account. But if somebody opened that account, it would delete that bankruptcy stop code. So all the collection letters and threatening letters and everything else would start back up. And what the the vice president had done was he did an analysis of how much it would cost them to fix that problem versus how much they were paying me for automatic stay violations and how many other attorneys were suing them throughout the country, and they determined it would be more beneficial for them to pay me and my clients than it would be to fix the problem.
You've got to be kidding me.
No. You know, what I was thinking when I had that memo is, should I just put that memo back in the stack and, you know, remember all the information that's in there, or should I say this is one that I want? Because if I wanted one, they would make a copy and we would base stamp it, and I would get a copy with the same base stamp numbers on it, so they would know I had it. And I was debating that for a little bit in my mind, and then I finally said, you know, if I don't get this document, there's no way they'll ever admit they did any of this stuff. So I gave it to the lawyer who was there for the associates, and we copied it, and I stayed there about another 30 minutes just for the hell of it, and we left. And the next day, the general counsel called me, and, you know, we had some very good settlements thereafter.
Well, I don't know, Mr. Gardner. I would have been a little concerned if I were you. I mean, here you are sitting in a big, gigantic warehouse out in the middle of nowhere that you said is the size of 3 football fields and no air conditioning, which sort of resembles the warehouse at the end of the movie Indiana Jones that it shows like, you know, thousands upon thousands of crates, and one of them has the Ark of the Covenant in it, and you're sitting in this kind of, you know, similar situation, and all of a sudden you're sitting there and you find a holy grail kind of document that helps you get settlements. I mean, what would you have done if all of a sudden, when you're looking at this, you know, thinking to yourself, all right, I got the holy grail, if all of a sudden you heard over your shoulder the door lock and you're locked in there with your information?
I had them in a very small room with no doors and no windows, and I was the only person that knew how to get out.
I should have seen that one coming, Mr. Gardner. I mean, of course you would have the perfect answer. I mean, you're a super attorney.
Is that the reason why all those cases were settled by consent, and the amount of the settlement was not disclosed pursuant to the stipulation of the release? Is that the reason why?
Yeah, it finally got to the point that all we would have to do is if a debtor got in bankruptcy, got a demand or bill or statement or telephone call or whatever it was, that we would just, back then it was by fax. I mean, a real fax machine, not e-fax, but I would fax proof down to a member of the general counsel's office of the associates, and we had a predetermined amount we would settle for, and he would send me a release and a check. If that amount went up, I mean, you know, we would stay at a certain amount for 3 or 4 months, and it would double, and then we'd stay at that amount for another 3 or 4 months, and it would double. And I remember when Citibank made the announcement. Well, I think 2 days before they made the announcement, they were buying the associates. The senior general counsel called me up and said, "I got some bad news for you." I said, "What? What is it?" He said, "Citibank is buying us." Of course, they fired everybody that worked there. But yeah, that was a sad day for a lot of my clients. Citibank fixed the problem.
Well, is Citibank continuing the problem?
I think the problem continues. I mean, you know, we still see, you know, automatic stay violations. I think we see more discharge violations by debt buyers or debt collectors attempting to collect debt that they know has been discharged in bankruptcy, but you know they're buying it for a penny or 2 cents on the dollar. They're buying all the Chapter 7 charge-offs of Chase or Citibank. They're buying all the Chapter 13 claims of Chase or Citibank. And you really have to understand how that process works. It's a pretty much an automated process. And those are the kind of agreements are called asset purchase and forward flow agreements. So it's like a train continuously running from here to California and back. The claims are being sold as soon as the bankruptcies are filed, and the debt buyers are starting to collect them as soon as they get them. So it's a big problem.
Well, Mr. Gardner, you're online like I am, and I'm sure that you've seen a lot of the different things like foreclosure remedies and things like that. But you've also seen, I'm sure, the bank litigation out there, or certain law firms pursuing certain legal angles and filing lawsuits against the banks. Since you're a super attorney and you can see things from 30,000 feet high, in your opinion, where should the homeowner be suing the bank? Or, what should they be suing them for? Where are the banks legally vulnerable, in your opinion?
Well, it depends on what kind of case you've got, John. I don't think there's one, weak area or weakness you can pursue. I think probably their biggest problem is the storage and maintenance and security of important records and documents. And with these new electronic e-sign mortgage notes and all coming into play, I think that's going to be even a bigger problem.
Right, and that was one of the questions that I had for you was because the banks are doing more e-signatures and e-recordings, and because now they're utilizing the UETA, the Uniform Electronic Transactions Act. How do you see this as far as is this problematic, or can it be problematic in people's cases?
Do you know what Ashley Madison is?
Ashley Madison, I've heard of it. Isn't that a website?
Yeah, that's a website. That people that wanted to have affairs while they were married or with a significant other, they joined Ashley Madison, and that website was hacked about 2 weeks ago, and I think they just disclosed all the names of all the members in the last week or so. So it's caused a lot of problems for husbands and spouses and wives and every significant others and everybody else, and probably a boon for the divorce business. But one thing that Ashley Madison promised to all their users was that everything you give us is totally secure. There is no way anybody can ever find out that you've used the Ashley Madison website. And it's tamper-proof documents. In other words, it would be impossible for anybody to change anything in our system or to find out you're a member or to get any information. We're totally secure. And, of course, that turned out not to be the case. And just think of all the records of the IRS that have been hacked by the Chinese and all the other government agencies that have had security breaches. So you start thinking about that, and then you start looking at this, the idea of electronic mortgages and notes. And, of course, this goes back to 2000. That's when that act was first put into place. But, it's something that is, it's happening now. I think probably up until this year, there may have been 400,000 e-notes and e-mortgages that have been originated. And that's mainly through Fannie and Freddie. Fannie and Freddie were the first to use the electronic signatures in Global National Consumer Act. In around 2001, they started doing some e-notes and e-mortgages. But, it's going to be a big thing, I think, from here on, because I just probably 2 weeks ago, there was a proposed amendment to Federal Rules of Evidence. It's not effective yet, but it will be. And what it is going to do is try to make the electronic records self-authenticating under Rule 902 of the Federal Rules of Evidence. They've added a new section 902.13 and 902.14 that basically says, a record generated by an electronic process or system that produces an accurate result as shown by certification by a qualified person, is admissible into evidence without any further authentication or foundation. So, I mean, you see where this is going. I have a real problem with electronic records, computer records, computer data, and how easily that data can be changed or manipulated by anybody that has access to it, not to mention a hacker.
Well, it throws caution to the wind. I mean, it's like they're throwing caution to the wind, and it's very problematic when you go into court, because how can you authenticate these documents?
Well, that's why they want to amend the Federal Rules of Evidence, make them self-authenticating. That's this amendment to Federal Rule of Evidence 902 would if you just have an affidavit, and you know those affidavits are going to be prepared by somebody that has no personal knowledge of anything. They're going to file that affidavit with a printout of the life of loan history on the mortgage, and unless you object to that on time and the court allows you to depose that person, then that evidence, that electronic record, would be admitted without any further foundation or authentication. I mean, this is out there right now. It was proposed in July of this year as an amendment to the Federal Rules of Evidence. So I think it'll be effective next year. Rule 902, 13, and 14 are new rules that basically provide that, you know, any record generated by an electronic process or system that produces an accurate result, if somebody signs an affidavit that says that and attaches the record to it, and no objection is timely filed to it, then that's in evidence.
Mr. Gardner, I find that I would assume, and this is completely conjecture, I would assume that a lot of attorneys are not even aware of this act, much less not being aware to object to it in a timely manner. And that's a very frightening thing.
It's just proposed right now by the commission that drafts, you know, proposed changes to the Federal Rules of Evidence and Federal Rules of Bankruptcy Procedure and things that the Supreme Court can authorize and approve. But yeah, it's very troubling to me because I have so much of I've seen so many life of loan histories that have been, you know, doctored or fabricated or created or recreated. I know that systems of record can be manipulated or changed or modified, and you know, you're going to have time to object to this if you know to object to it, but it's going to be a discretionary thing, I think, with your judge about whether or not the judge is going to let you really take the deposition of whoever signed that affidavit saying this is a true and accurate record as generated by our electronic process or system of record. I mean, it's going to be another way they can, you know, shortcut the whole system. So if you think that all the DocX affidavits and the assignments, the mortgages were problems, then this is a bigger one, in my opinion, on the horizon.
Do you find that, have you had any success in questioning the validity of the DocX document?
Well, you know, what you have to be prepared to do in these cases is you've got to do, you know, discovery. You have to go out and take depositions of whoever signed an affidavit or whoever executed a launch or whoever's name appears on an endorsement to a note or whoever's trying to authenticate a business record. And you know, you have to go beyond that, and you've got to be able to spend the time and money to do it. There's no easy way to get to these cases. Most of these people are really just, you know, professional witnesses is all I can say, and they really don't even work in the servicing center for whoever the creditor may be. They just sit around sign these affidavits all day. And when you get down to the nitty-gritty and really ask them, you know, pinpointed questions about how their electronic or computer systems work and function, they can't answer them. They don't know.
Well, Mr. Gardner, let me ask you, how many mortgages do you think have this problem in them?
Well, it depends on what kind of problem you're talking about.
Well, I'm specifically talking about, forged documents or evidence of forgery.
I think and I don't use the term forgery much because it's been used to the extent that if you say that term in court, I think a judge is going to think that, maybe you don't have a very good case. I like to use the word, this was not authorized. There's no legal support for this particular act by this particular person. But to get to your question, if you're talking about, for example, mortgage loan and the systems of record that are supposed to track those payments and how payments are applied or misapplied, and you start talking about, if somebody is late and there's a late fee, and then there's a property inspection, and there's a broker price opinion, and then there's a fee for a notice of default. When you get into that, I have serious questions whether any mortgage servicer has a completely accurate life of loan history. I mean, it would really be valid, and they really applied the money the right way, and they didn't gross up the charges, like they pay $5 for a property inspection, then charge the debtor $75 for the property inspection. I have serious questions about the accuracy of any of those records.
You have several cases in which there was the debtor alleged that the settlement of a prior motion of relief from stay, you allege that the home side breached this. They were adding secret sums and legal fees and charges to their own loan balance, and then because of a lot of these servicing companies going under, when they transferred, a lot of those loan histories were not accurately transferred to the new owner. Is that what you're finding?
Well, I mean, I'm finding it with the original servicer or the default servicer, but any time servicing rights are transferred from, and Ocwen is selling a lot of servicing rights these days, and Bank of America too, but any time servicing rights are transferred from one servicer to another, there is going to be a major problem when that new servicer boards up that loan. I mean, they may be running two different systems of record, like Ocwen runs something they call RealServe. Wells Fargo runs something called MSP. They're totally different computer systems. I mean, there's no way you could integrate those together. So, there are going to be major problems, I think, anytime servicing rights are transferred with boarding that loan up by the new servicer. And, the old servicer may load up every kind of fee or charge that they can think of to that account before they sell it, because they're going to get reimbursed and paid for any recoverable fees that they have not been paid at that point. Plus, the servicing rights have a value, so they're getting paid for the servicing rights. Plus, they're getting reimbursed for any advances they say they made that they have not yet recovered from the investor. So it's a major opportunity to gross up your corporate advances, as they say, on every single loan that servicing rights are transferred for.
Now, Mr. Gardner, you said Ocwen and Bank of America, which is what I was with. And until recently, or I should say, before last October, I believe that my loan was sold off to another investor. And so I'm no longer with Bank of America or Ocwen as far as what they tell me. I mean, why do you think they did that? And the reason I'm asking is, it kind of hurt my feelings. I mean, what do they not like me or something? I mean, what's wrong? How come nobody wants me?
I mean, you've got to remember that they're not, in most cases, selling your mortgage note. They're really just selling the rights to service or collect payments or foreclose or whatever they're going to do on your loan. Ocwen is doing it because they really need them to raise the income to maintain their lines of credit. I mean, Ocwen is in serious financial trouble. You can go to the SEC website and look at their most recent 8K financials and see, the kind of problems they're having. But, Ocwen is not doing this on a voluntary basis. They need the money. They need the cash to pay down their lines of credit. So they still have lines of credit open for them. Bank of America, was getting a lot of heat from Fannie and Freddie and FHFA, this conservator for Fannie and Freddie, to sell a lot of their Fannie and Freddie loans that were servicing rights to those loans. So that was really where Bank of America was getting the heat from. Bank of America's actually been buying some servicing rights in the last 5 or 6 months. So, the Dodd-Frank Act, servicing rights actually are considered to be not an asset, but really a liability these days. So that was one reason a lot of the banks were selling servicing rights to try to get their balance sheets in line with the liquidation requirements of the Dodd-Frank Act.
I have to shift gears a little bit, if you don't mind. I've been wanting to ask you this question, and I've been aware of this for about 2 years now. You had a case called Blayton versus Citicorp, okay? And in that case, this was one of the first cases where you had questioned or used issues regarding intentional infliction of emotional duress. And then what you've done is you used the psychologist document. Let's see, it says here, psychic trauma and psychic injuries rising out of willful violation of the automatic stay. Have you and or your attorneys that you're aware of have been using the intentional infliction of emotional duress and or negligent infliction of emotional duress? Is that becoming more and more common as far as utilizing that as a cause of action?
I like to find a good statutory claim. For example, Reg X, which is something that the CFPB enacted in January of 2014 under RESPA, and then they also amended Reg Z at the same time. But Reg X requires actual damages to pursue a violation of Reg X, which are rules related to the servicing of mortgage loans and the modification of mortgage loans. Reg X covers both. You have to prove actual damages. So, people have been focusing in more. I've tried to get them to focus in on more of cases where you've got a statutory cause of action that allows for the recovery of actual damages, and then to get really creative in terms of figuring out what those actual damages are. And, emotional issues certainly come into play. I mean, if you're under duress from your mortgage servicer and concerned about whether you're going to keep your home or not keep it, and you've got, say husband and wife, and maybe the wife wanted to get the house, the husband wanted to get the house, or one wanted to refinance and the other didn't. I mean, there's all sorts of incidents that occur between spouses in that case that are caused by the servicer threatening to take their home, and you've got to look into those. I mean, sexual relations with family, work relations, interaction with children, or father, grandfather, grandmothers. So, we're trying to really explore those in terms of actual damages. And plus, I'm, looking at how many times did my client have to drive to see me and keeping the miles at the federal mileage rate? How much time have they lost from work in dealing with this case? What have they spent on postage, writing to their servicer with a request for information or a notice of error about what is wrong with their account? Sending that certified mail return receipt so you can prove they got it, because otherwise they'll claim they didn't get it. There's just a lot of damages that are there, and I like those in terms of a statute that gives a private right of action and provides for action.
Well, I'll tell you something, Mr. Gardner. I've talked to so many homeowners where the husband has had strokes, wife has had the heart attack, the destruction of marriages. It's an amazing, complete destruction of families, of individuals. The foreclosures have been completely disrupting the whole family system. And I think it's wonderful to go after and utilize the IIED or NIED because the families have been destroyed. How much success have you had with this?
Well, I think we've had a substantial success with it. But you know, like I said, there's no magic bullet on any of this stuff. Any lawyer that tells anybody that there's anything easy about this, or there's a magic bullet or a magic potion, or I'm Houdini, or I've got the secret to you know, save your home, or it's just not true. These are all, you know, hard cases and difficult work. But you know, what I try to do is to put myself in you know, the shoes of. I'll give you an example. I had a client in here a week or so ago, and we were talking about modifying his mortgage loan. And really, there have been, despite the failures of the HAMP program, there have been some real successes with modifying mortgage loans for people that know how the system works. And it's a very complex system, and you got to know what to put in your request for mortgage assistance, and how that whole NPV test works, and how the waterfall works. But anyway, I was saying, I think we can get your payments reduced probably by about 50 or 60%, and get a principal forgiveness of maybe 40, 50%. And you know, his question to me was, he said, Max, have you been out in my neighborhood lately? And I said, well, no, I haven't. As a matter of fact, it's probably been 5 or 6 years since I've been out in that area. He said, why don't you just come out here and ride through one afternoon? And then you decide, would you want to live in this neighborhood or not? And, of course, what he was talking about, now I took him up and I actually went out there. And what he was talking about is all the homes that are vacant or empty, you know, the zombie foreclosure victims. I mean, you're not, even if you're still in your home, it's not vacant. Are you going to spend $5,000 at Lowe's to redo your kitchen if you think your home's going to be foreclosed, or to put a new roof on the house, or repair a window, whatever? I mean, you know, I think you just have to understand, you know, what life is like in a neighborhood like that to really appreciate the problems out there that have been done. And you know, I don't think a lot of people understand, you know, a fear of opening the mail or opening the door, or somebody driving up with court papers to be served on you, not knowing if you're going to be in that house next week or next month or 2 months from now. You know, nobody's really done any kind of thing in the media that talks about that kind of situation.
Well, one of the items that you brought up very quickly is the FDCPA violation. I know that there are more and more attorneys being aware of the FDCPA violations. Can you speak about that a little bit?
Yeah, it's you know, the Fair Debt Collection Practices Act is just a strict liability statute, and it applies to consumer debts and applies to debt collectors. Now, mortgage servicers are exempt from the FDCPA unless they acquired servicing rights at a point in time when that loan was in default. So, you know, Ocwen, for example, is primarily a servicer of default mortgage loans. So, with anytime Ocwen is involved, you pretty much know that this loan was in default when they got servicing rights. Obviously, when Ocwen sells servicing rights to a loan, it's in default. So, you know, the chances are real good these days that your mortgage servicer is going to be subject to the Fair Debt Collection Practices Act. and it's a very powerful statute. And if they misrepresent anything about the debt, for example, the amount you owe, the amount you're behind, any fees or charges they say they've added to the account or advanced against the account, what they've done with your escrow money, you got an FDCPA violation. So, you know, that, and I think probably one of the more powerful things that has come about under Dodd-Frank is the Consumer Financial Protection Bureau and what Bureau has done in terms of regulations under the Real Estate Settlement Procedures Act that applies to servicers, Reg X, and what they've done on Reg Z, which applies to creditors, about what standards must be followed in order to service somebody's mortgage properly. And there's a private right of action under Reg X for the majority of the regulations in Reg X, and of course under Reg Z, private right of action under the Truth in Lending for a violation there. So, and all those are fee-shifting statutes. So if you prevail, the attorney fee that you would otherwise pay your attorney has got to be paid by the creditor, debt buyer, debt collector. And there's a split right now in the federal courts about whether the FDCPA applies to somebody that's in bankruptcy. The majority of the federal courts hold that it does apply, that somebody in bankruptcy can also have a FDCPA violation. I mean, a very recent case held that the filing of a false proof of claim 13 case would be an FDCPA violation. In that case, the proof of claim was one that was outside the statute of limitations. In other words, the time to actually sue and legally collect that debt had expired. The claim was filed in the bankruptcy as a sworn proof of claim, and the 11th Circuit said that's an FDCPA violation. So it's a very powerful statute. And just because somebody is foreclosing on your loan doesn't mean that they're not subject to the FDCPA. The law firm may be, the servicer may be, the substitute trustee may be, if they're trying to do anything to collect that debt or implying they're trying to collect that debt.
It's a lot more powerful than most people give credit for.
Yeah, that and your state unfair and deceptive practice statutes are important into account. I mean, there's just a large number. These are not, show me the note type legal theories, or they securitize the mortgage note the right way type theories. These are real solid statutory claims that there's no doubt that the consumer has standing to pursue those claims if they're properly identified and proven the right way.
Well, also along the same line, you also mentioned earlier in our conversation about the securitization. I know there's a lot of attorneys that do not use the securitization aspect in arguing and as well as in the claim causes of action. Have you had any success, or can you talk a little bit about the securitization problems that a lot of homeowners don't realize that they have?
Well, the vast majority of cases have held that a homeowner has no legal standing to attack a securitization of their note as they didn't follow the rules they're supposed to follow, or the note was not properly transferred from A to B and B to C and C to D. But I think it's very important to understand how that process is supposed to work, because that can give you ways to lawfully attack when a servicer or a trust is coming into court with a note and endorsements on that note. You need to just understand how that process is supposed to work to be able to make a substantive attack on what they're trying to establish. Is the proper note. For example, I mean, you may see a mortgage note that was originated by, say, New Century Mortgage, and it'll have an endorsement on it from New Century directly to Morgan Stanley Trust 2006-7. Well, that would be a restricted endorsement directly from the originator to that trust. If you know anything about securitization, that couldn't have happened. He essentially would have sold that note to a sponsor for the trust, and the sponsor would have sold it to the depositor for the trust, and the depositor would have sold it to the trust. So there's no way that the originator could do a restricted endorsement skipping over those two intermediary parties directly to the trust. So it just gives you a factual way to, when you're deposing that person did the assignment or the endorsement, to try to explain how that happened.
Well, what about these endorsements that are in blank?
Well, those are pretty easy to create. I don't know, 5 or 6 years ago, I just thought I would order some endorsement stamps just to see if I could get them. I just went down to Office Max in Shelby and where I live and ordered 7 or 8 stamps that said I was vice president of Wells Fargo or Bank of America or Countrywide. I think Countrywide was out of business through the merger with Bank of America, but was still seeing a lot of Countrywide endorsements. And I got all of them without any trouble. They didn't have any questions. So, yeah, I had about 5 or 6 stamps that, I'm at third vice president, Wells Fargo, in the order of blank.
Mr. Gardner, I have another question for you. Over the years, you've seen the Justice Department say that they investigated the banks and they looked for, fraud, but, they see some shenanigans, but they don't see anything that they can use that they can actually, use as fraud and prosecute them. I want to know what your opinion was about that.
Well, my opinion is that I'd like to talk to the attorney that came up with that opinion, because I've got some serious questions about that. The only thing I can say is, the former Attorney General was with a very big law firm before he was Attorney General, and now that he's no longer Attorney General, he's with that same big law firm. Anything wrong with that, but I'm just saying.
So you're saying you're suspicious and that you see something there that maybe they could be prosecuted on. Is that what you're saying?
Well, I mean, there's obviously been some substantial amount of misconduct involved, but what we've seen is no real criminal prosecutions. We've seen a lot of civil actions filed where the remedy is that they're going to pay $25 billion to settle the case. Then you start looking at it and it says they're going to get credit for modifying loans, and then they're going to get $2 for $1 credit, and then you start looking at, is there any real money involved in this at all, and who's the money going to? And if any's going to the consumer, it's like $199 for everybody that was involved in that particular activity as a homeowner who was somehow harmed or damaged. It's not something I would consider a real remedy in that situation.
I'm sure it's safe to say, and I'm sure a lot of bank attorneys will actually agree with me on this, that you're one of the most feared attorneys by bank attorneys. You just have some serious wins. And when I sit and I think about that, and I think about how the financial institutions watch their bank attorneys get rolled down like bowling pins, I think about how the banking institutions have to, at one point, think to themselves, if you can't beat them, join them, or maybe have you join them. And what I'm saying here is, has anybody at the banks or any of these financial institutions ever offered you a job?
Well, as a matter of principle, it would be a breach of ethics and trust on my part if I sold out to any creditor and said I'll work in your general counsel's office for $5 million a year, $2 million, or whatever. I just couldn't do that.
Now, I noticed that you said $2 to $5 million a year. Is that what we're to presume they offered you, Mr. Gardner?
It was, I've had some attractive offers, John, I'll say that. But it's just something that I just never really seriously considered. Now, some of them have been, some that you sit around and have to think about for a minute, but it just wouldn't be the right thing for me to do. Not the right representative, but for everybody that's been through my boot camp. I mean, everybody's got a price. You always hear that, but the way I see it, there is no price.
Well, I really appreciate your integrity and your answer, Mr. Gardner. Thank you. My next question has to do with the judges. Mr. Gardner, what do you think about some of these judges who think that it doesn't matter whether the banks have the note or not, that the homeowner, they borrowed the money and they got to pay the money back? That the judges are, biased or... You know what I'm saying, Janet. Maybe you can help me out here, Janet.
A lot of judges perceive homeowners as deadbeat homeowners, and without realizing, not even realizing, without even giving, I guess they perceive a lot of homeowners as deadbeat homeowners without acknowledging the fact that the banks have had some real issues with securitizations, falsifying documents, just like DocX. So I guess the question is how do you see a lot of judges who are beginning to understand that there are some real problems?
I think there's been a major change, especially in the last 4 or 5 years. It's been a long, difficult struggle. There's no doubt about that. The problem that I've had is that judges, up until the last couple, 3 or 4 years, have had special rules, it seems like, for mortgage cases than they would have for other cases. For example, if some fifth-tier debt buyer tries to sue my client for a Citibank MasterCard they had 10 years ago, and they can't prove up, how they acquired that account, what evidence they have that my client signed the card member agreement, the account statements, the computer records are legitimate, then that case is going to be dismissed, and there may be sanctions imposed on the attorney that filed it for filing a frivolous case. You turn that into a mortgage case, and all of a sudden it's the homeowner trying to get a free home. That's you got to give the mortgage industry credit. They came up with this free home idea, and the homeowners are deadbeat and they just want a free home. They're trying to take advantage of the system, or they're trying to scam the system or whatever. And that PR campaign was very successful for a long, long time. I've never had anybody that's wanting to get a free home. They wanted a fair shake. They want to have the same rights that anybody else would have in court if they were being sued. The same rules of evidence to apply, the same, how you authenticate documents and records and how you lay a foundation to introduce evidence. That's all they want. And, the government came out with the HAMP program, gave all this money to the banks to modify loans, and said there's no private right of action to sue under HAMP if you don't comply with that. There's just been a lot of mistakes and problems with everything that has been done. If there had been a private right of action under HAMP when that program first was rolled out, I think it would have made a major difference. If consumers could have modified first mortgage loans in bankruptcy, that was part of President Obama said that was going to be part of the HAMP program, is we're going to amend the bankruptcy law to let you write down your first mortgage in bankruptcy to the value of the home. And that wasn't passed by the Congress. It passed the House once, but never got past the Senate. Second time it didn't pass the House. If those two things had happened, I think things would have been substantially different than they have been.
Do you find that judges are beginning to become more sympathetic with the homeowners and understanding some of these critical issues, such as the securitization and the breakage in the chain of title?
I don't know if they've been more sympathetic to the homeowner, but I think they have been applying the standard rules of evidence and treating mortgage cases just like any other civil case should be treated than they have in the past, and just not accepting anything the bank or the mortgage servicer says about whether they own the note or the really bigger problems in my mind with the accounting that mortgage servicers do, how they the fees, the charges, the advances, the legal fees, the statutory fees, they call them the miscellaneous fees, the check by phone fees, the late fees, and then how they apply money they receive from consumers against the mortgage loan, just their basic records. I see more real serious issues there than with the securitization thing. Just as factory issues. I mean, the accounting is just a mess.
Yeah, one of the challenges that I've been seeing in some of the cases that I've been aware of is that some of these fees are gone. They've, when you ask for records, there have been times in which the servicing company says, well, the records came from a previous servicer and they don't have it, and so therefore they cannot give it to them.
They do have it. I mean, you really have to know what to ask for. I mean, that's one of the things we try to teach attorneys at the boot camps is, how does this servicing system work? What kind of reports can it produce? What do they call those reports? What are the names for those reports? Like MSP that I mentioned earlier that Wells Fargo runs, about 60% of the servicers run MSP, and it used to be owned by Lender Processing Services, and now it's owned by a company called Black Knight Financial. I'm thinking, who the hell came up with the name Black Knight? Well, it turns out the CEO is an Army grad, went to the U.S. Military Academy, and they're the Black Knights. That's their moniker, so that's where he got the name, but he probably didn't check with the PR department before he officially signed it. But, MSP has got probably 250 different reports that system can produce, and each one has a specific name or code for that report. So it's important to know, what to ask for in discovery and what to look for.
Well, how are you supposed to find out about those individual reports? I mean, do they have a list?
Oh, yeah, absolutely. I mean, I've deposed enough people that have been in servicing centers that run MSP. I've actually been in mortgage servicing centers for physical examinations. I've interviewed former employees of servicers and of LPS and Black Knight. So, just got to keep asking questions, and, the more you ask, the more you find out. So that's, it's just, there's no one place you can go and look for that. I tell attorneys that come to boot camp is one of my objectives is when you leave this boot camp that you're going to know more about how the creditor operates, how they do business, the systems they use, the third-party vendors they use, what they outsource, what they don't outsource, where they do things, like do it in Florida or Texas or India, the Philippines or Panama or South Vietnam. Where do they do that? What do they do over there? How do they communicate back and forth? What are the systems they use? What do they call the communiques? Everyone's got a different name for it. So, it's just important to really dig deep down into every creditor's business model and find out how that thing's constructed and understand how those parts fit together from their point of view to really get to find out what's really happening.
One of the things that we have not talked about throughout this time, and I want to bring it up, is MERS, Mortgage Electronic Registration System. Now, I know that you've been very instrumental in suing the banks and everything else. Have you had any situations, or have you had any luck in suing? And can we talk about MERS for a little bit?
Yeah, sure. There's no life on MERS.
Do you bring in MERS as one of the defendants, or as a defendant in any of your cases, or no?
I really don't. In North Carolina and in probably half the states, we have a statutory rule that's really based on the Old English common law that the mortgage follows the note without having to do an assignment. So to me, the key document has always been the note, the promise to pay, to follow it, because in North Carolina, we're a deed of trust state like California, not a mortgage state, but the deed of trust automatically follows the note without having to do an assignment of record. So, from the point of view of MERS assigning stuff and MERS officers and all that's never just been an issue. What I have been concerned about is, MERS trying to make itself out to be a verifiable, secure system of record as to who owns the note and who is servicing the note at a certain time. Because everything there's no way in my mind that the MERS milestone reports or milestone plus reports could be considered a business record. MERS has no idea if the data is being entered or not entered every time servicing rights are sold or every time the note is sold. But they don't know. There's no way they can know. When the data is entered, nobody at MERS reviews it to see if it's accurate. There's no safety checks, no double checks, no verification. It's just there. And every audit that I've seen, I know Jay Patterson, who's one of our instructors at the boot camp, he's in Little Rock, Arkansas. Jay has audited for the San Francisco County Register of Deeds, and up in Oregon, I know those two audits he's done on MERS. But what he's found out in most of those audits is that well over 70% of the information in the MERS system is not accurate. It's not consistent with what he can find out through, SEC searches and investor reports, actually who owns the note or who is actually servicing that note at that time. So that's been my biggest problem with MERS. In theory, maybe it sounded good to start out with, but the way they put it into operation, even in 2010, MERS testified before Congress, their vice president, that he didn't know how many vice presidents or secretaries they had. Maybe 23,000, but he didn't know who they were. And
wow.
Then they were forced by federal regulators to adopt some system so they could at least know who their officers were. So they at least now they do know who all their officers are. Not that they know what they're doing, but at least they know who they are. They are registered and have to be recertified every year. But they've got a pretty difficult test to take. Like, the first question is, what does MERS stand for? Second question is, MERS located in Virginia or Minnesota. I think there are 10 questions and you have to get 7 of them right.
Oh, my God.
Mr. Gardner, I just heard you say the word audit, and that brought up another question for me. It's not so much about what you were talking about, but when you said audit, I was thinking land audit, because Janet and I are both working on a story that has to do with a land audit being done in Florida, and then there was scandal because an attorney came on the news and said that it was a waste of money, and we tried to have a panel of a debate with both sides, but one side wouldn't show up. It was an absolute mess. But my question isn't about the mess. My question is what it's always been since the beginning, which is, how relevant do you think land audits are? Because in my opinion, even though the person who conducted the land audit might have been potentially discredited. I mean, we all know that there's some real problems existing there at the county clerk's office when we think of John O'Brien and what they're all saying. But my question, let me be specific here. How relevant do you think land audits are?
I think they're very important to show how flawed the MERS system of record is. I mean, it's just not an accurate business record. But in terms of whether the Register of Deeds of the county can sue MERS for damages for not filing an assignment every time the note was sold and assigned to the mortgage or deed of trust, I'm not so sure that those cases are going to be that successful. You take North Carolina, for example, with the statute we have, which is pretty common, that if the deed of trust is recorded at origination and the note is sold, you don't have to do an assignment of that deed of trust every time the note is sold. It just automatically follows the note as a matter of law without having to do an assignment. So if that's the law in your jurisdiction, then there wouldn't be any recording fees that would have been lost because no assignments would have been necessary. If you're in a jurisdiction that requires an assignment every time the note is sold, then you maybe have some damages there. I think those are very few and far between those jurisdictions. The thing about MERS that is just kind of a bizarre thing to me is when Fannie and Freddie started MERS, and they own over half the stock in MERS right now. But why they didn't, in 95, 96, when they were developing the MERS system, why didn't they come up with some uniform act that said, if you're going to use the MERS system in this state, here's what you have to do? I mean, we have uniform acts on everything. There's a new Uniform Foreclosure Act that's been rolled out now for all the states to consider. But there was no underlying statutory law that said this is how the MERS system is going to work. They just decided we're going to do it. And, of course, back then, if Fannie and Freddie did it, everybody said, well, it must be legal. If Fannie and Freddie can do it, I guess we can. And I think that's the biggest mystery about MERS to me is how they would roll out a system like MERS. MERS originally was, they would sue and claim they were the holder of the note. And then they lost so many cases on that, they decided, well, that's not a good idea, and actually put in their bylaws that if a member filed a foreclosure case or any other case and claimed that MERS was the owner of the note, they'd be fined $10,000. So the thing was just a cluster when it started out, and when you get something that screwed up starting out, it's hard to get it back on the track.
So basically, I guess MERS was hell paved with good intentions, right?
Well, I don't know if it's good intentions. I think it was to save money where they had to record things and to have a central repository, a database of information that anybody could look at any time and figure out. I'm talking about investors or servicers or attorneys for mortgage servicers could look at and find out, well, who owns this note right now and who is the current servicer? But the system just wasn't. I mean, there's no integrity to the system the way it was set up and organized and structured and functioned. So. But, the intentions of the creditors are always, how can we eliminate expenses and how can we make more money?
So I think if I'm hearing you correctly, you're saying that the MERS system was created with no integrity and no accountability in mind. Is that correct? Is that what I'm hearing you say?
I think that's I'm not going to say everybody, because it's never everybody, it's never everything, but I'd say the vast majority. You go back to the companies like the Associates and AFCO Financial and that whole business model. The debt buyers that are out there buying up all sorts of debt that may be 30 years old or may not even be your debt. it's all about a system that are we making more money than we're losing because we're not complying with the law. You got to just think of it that way, and I think that's the way most creditors, debt collectors, debt buyers look at it. What's the cheapest, fastest, quickest way to do it, and how can we make the most money doing it? And if we're violating the law, that's just the cost of doing business, and they want to keep that cost as low as possible. Just one thing, talking about the endorsements of the notes in blank. If you look at a lot of the recent cases the last year, the difficulty that servicers have had in court proving that they had possession of that note endorsed in blank before they file the foreclosure or whatever kind of action they file is pretty incredible when you think about anybody can go to Office Max and order 5 or 6 stamps that you can stamp on anything you want to and create a bare instrument, an endorsement in blank. Probably an amazing development to me.
And it's very shocking to me, only because of the fact that so many banks are now going towards the endorsements in blank. And a lot of attorneys are not aware of the fact of questioning as far as when they receive, because these endorsements in blanks are not dated.
No, that's one thing. UCC Article 3 doesn't require that. And it seems to me like that would have been a minimum thing to put in there, but it's not required by the Uniform Commercial Code. The thing that you got to remember is there's always in every deal a master document custodian is supposed to get these original notes and the original mortgages and deeds of trust and the HUD-1 closing statement, the title insurance policy, and they're supposed to maintain those records for the servicer, and they book things in when they get them. So, if they got a note that wasn't endorsed back in 2006 and somebody created an endorsement in 2015 and sent it to that custodian, they would book it in 2015. So, I just wanted to throw that out that to me, in all these cases, the major party that I want to get involved in with discovery is the master document custodian for whoever claims to be the holder or owner of that note. In other words, I'm saying there's ways you can find out when that note was endorsed.
Outstanding.
Well, I'm glad that you brought up that point, that we can verify when that was endorsed, because I think that, for a while there, I was wondering if there was just no way to verify anything, and maybe that's why they're doing it and getting away with it. But, Mr. Gardner, I was listening here to you talk about some of these legal points and sort of closing my eyes and imagining what it would be like to hear you talk in the courtroom and talk about some of this stuff you were talking about with the custodian and the notes and different things. And the first thing I thought of is if I'm in New York and I'm a New York judge, I'm going to recognize that you kind of have a southern drawl to your tone when you talk, sort of like mad log. And this kind of leads me into a fun question. Mr. Gardner, when a country boy like you from North Carolina visits a New York courtroom where everything's slam, bam, and thank you, ma'am, what does a New York judge say to a country boy from North Carolina about his southern accent in his New York courtroom?
Can you talk faster?
So, basically, they never mentioned your southern accent, but just asked if you could talk a little faster.
Oh, they said that. Yeah, they'll say that. I mean, when I got out of high school in '64, I went to Anchorage, Alaska, and worked for a bank up there called the Matanuska Valley Bank. So I've actually worked for a bank. I was the assistant vault teller and armored guard for the bank. And my armored car was a 59 VW Beetle seat in it. And 4th Avenue in Anchorage back then was just, one bar club after the other. And it ran, 24 hours a day, kind of like Vegas. And but people used to ask me to come to bars, and they would buy my drinks if I would just talk.
I should let you know, I lived in Alaska for about 5 years three of which was at the University of Alaska in Anchorage. And I lived in Bethel, Alaska, for about 2.5 years. I don't know if you know where Bethel is.
Oh, yeah. You know, one thing I got to do, I lived in Spenard. You know where Spenard is?
Yes.
I lived down in the valley in Spenard, but one thing that I had to do as the assistant vault teller is if we had opened a new account anywhere in Alaska, then we had a plane that we would fly out. If we had 3 or more accounts in Nome or wherever, I would fly out there and, you know, have the consumer sign the necessary paperwork to open a checking or savings account at the bank or buy a bond or whatever they wanted to do. And so I got a chance to go to every single place in Alaska, whether it was you know, the Indians or the Eskimos or somebody from California or wherever. I mean, you know.
What did you think of Nome?
What, you know, Alaska was like, I mean, it was such a big place, and, you know, just so wild and frontier-like, and, you know, back at that time, the people that did the construction work, you know, they would work from like May to September, and then they would just have a party the rest of the year. It was a wild time, but yeah, I have worked for a bank, the Matanuska Valley Bank, and you know, Anchorage is in the Matanuska Valley, so
yeah,
I don't know if the bank's still around or not.
I don't know. When I was in Bethel, I always tell people when I was in Bethel, I was there when it was 98 below zero. It was 70 below ambient, and then with wind chill, it was 98 below. And, you know, those numbers and that temperature was incomprehensible to most people. But I think you would understand that.
Well, that and the snow, I mean, you know, we had like 190 inches of snow the first winter I was up there, and you know, maybe we'd had 20 inches at the most here, but I mean, you know, when it snowed up there, it didn't melt. It just kept building up and building up and building up. That and the cold and having to, you know, plug your car in at night to heat keep the engine block heated so it would crank the next morning. I mean, things like that. Not staying outside for too long because your lungs would freeze. Yeah, that was a little different.
Well, especially you coming to North Carolina, that's something that is totally opposite of what you're normally used to.
Absolutely, yeah.
Well, Mr. Gardner, we're getting close to the end of the interview here, and this is where I like to ask all the hard personal questions, such as, you know, how I asked you about your accent. And with that being said, we're going to move forward here with some of these hard questions. Okay, Mr. Gardner. My first question is this, and it has a multiple choice answer. You seem to be on the internet quite a bit with the kind of line of work that you're doing, and I know that you've recognized that there's several other bloggers out there on this topic. And therefore, Mr. Gardner, I would like you to tell us which one is your favorite blogger. A, John Wright from PiggyBankBlog.com. B, John Wright from PiggyBankBlog.com. Or C, John Wright from PiggyBankBlog.com.
All the above. Test in law school, you know, and it would be the multiple choice. Is it A? Is it B? Is it A and B? Is it A, B, and C? Is it none of the above?
Well, you're not the smartest super attorney out there for no reason. I'll accept that answer. Mr. Gardner, my next question has to do with the Piggy Bank Blog 2.0 YouTube that I released when I announced that I was coming back to blogging. I had spent quite a bit of time making that YouTube, which encapsulated a lot of my feelings in my statement, and posted it on the blog, as well as one day I posted it on Facebook and announced that anybody who didn't hit like or share on it, that I would throw them off my Facebook as my friends. And followed up with saying not to worry, because when I came, when I left blogging the first time, I deleted over 1,000 friends, but now only had 54 friends left, and probably would realize that and re-invite everybody to be my friend a week later. Kind of a tongue-in-cheek. But anyways, I did post that, and you actually responded in public and stated that you liked the YouTube so much that you were wanting permission to use it at your boot camp. And of course, I was absolutely thrilled. Mr. Gardner, with that being said, could you please tell us what it was that you liked about the Piggy Bank Blog version 2.0 YouTube that I released?
The production quality was pretty good. And anytime you can put humor in something, get the message across. I mean, I read a lot of stuff, obviously, and look at a lot of stuff and every day. And I'm corresponding with boot camp attorneys every day on our private email network, and reading a lot of cases and looking at a lot of things day and night. So there's a lot of stuff out there, that's for sure. So I thought it was very, very professional, John.
Well, I'm truly humbled by your compliment there, Mr. Gardner. Certainly coming from a super attorney and somebody as prestigious and particular as yourself. So I want to thank you, and I'm very humbled. Thank you very much. Mr. Gardner, I'm sure that you give to, charities. And so I would like you to please tell us, what are your two most favorite charities to give to?
Well, the Cancer Society and the Multiple Sclerosis Society are my top two, and I think, you can obviously understand why.
Well, I certainly do understand why, Mr. Gardner, and I hope the audience understands why, too, and thinks about giving something to the Cancer and the MS Society today. Mr. Gardner, my next question is kind of a fun question that can have a fun answer. Of course, you're under no obligation to answer the question if you don't want. But, Mr. Gardner, what is your favorite curse word?
Fuck.
Yeah, that's actually my favorite curse word too, Mr. Gardner. But for today's sake, I think I'll make my favorite curse word, holy shit. I just got myself a super attorney to curse on the air. Thank you for the honesty in your answer. Mr. Gardner, my next question has to do with your financial success. You are a clearly very financially successful attorney within your own right. And with that being understood, I'd like to know, at what point in your career did you know that you had finally arrived?
I think if you really think that you've arrived, or you know it all, or you're the best, or anything like that, it's probably time to quit. In this business, you never know it all. You've never seen it all. You've never done it all. There's something new every day, and so I don't think that I've ever felt like I arrived anywhere, or saw or knew more than anybody else. There wasn't anything left to know. The thing about the kind of law practice I've done is that there's 10 new things every day that you find out that you didn't know the day before, and that's part of the thing that kind of keeps me going is what else can I find out or learn that I didn't know the day before.
Well, I have to agree with you on that one too, Mr. Gardner. I think that that wasn't the answer I anticipated that you would give, but I thought it was a great answer, and I might even incorporate that as my answer. So thank you for answering that question next. Mr. Gardner, I think it's fair to say that everybody would like to have a legacy. What would you like your legacy to be?
Well, I think the work that people have done, the body of work that the attorneys that have been through the boot camp have done, the cases they've been involved in.
Well, I think that's a great legacy to have. And once again, I have to agree with you. I do think that's your legacy. Okay, Mr. Gardner. The next question I have for you is the last question I have for you during this interview. And it's probably, the single most important question I have regarding foreclosure defense litigation. And that's why I left it for last. Mr. Gardner, boxers or briefs?
Boxers.
Well, I guess we finally figured out your secret to winning all those cases, Mr. Gardner. It's been your super boxers the whole time. Well, Mr. Gardner, I want to thank you for being a guest on our show and answering our subpoena to come onto the Courts of Public Opinion radio show. I've had a really good time interviewing you, and I hope that you've had a good time too. And before I sign off and tip my hat and wave my hand goodbye to the audience, I'm going to turn the floor over here to my lovely co-host, Janet Reiner, to say a last few words to you before we sign off.
Mr. Gardner, I want to tell you how much I honor and respect your presence and answering our questions. And I want to thank not only you, but I want to thank your family for allowing and having the patience for you being on the phone with us as long as you have. So I want to thank you, and more importantly, I want to thank your family, your wife and family, in allowing us to have that time with you. And thank you.
Thank you very much. I've enjoyed it.
Well, we sure had a good time too, Mr. Gardner. And I really want to take this opportunity to thank you again for answering our subpoena and appearing before the Court of Public Opinion. Well, there it was, ladies and gentlemen. The super attorney Oliver Max Gardner III interview. You will find Mr. Gardner doing what he does best at his Max Gardner Bankruptcy Boot Camp or at his website at www.maxconsumerdefenseacademy.com. I now leave you today with reading a thank you email that I personally sent Mr. Gardner shortly after posting part 1 of this interview. Dear Mr. Gardner, Janet Reiner and I would like to take this opportunity to thank you for granting us this interview. We would like to also thank you for the spirit of cooperation you showed us in preparation for the show, as well as thank you for all the personal pictures from your childhood. P.S. It's really too bad you didn't have a picture from when Uncle Ralph took you to that first strip bar when you were a young man. Highest respects, John Wright, PiggyBankBlog.com. Dear John, there's just some things a young man never loses. Please see attachment, Oliver Max Gardner III.